can't just sit around and not do any more videos. I had to, I found this article because I'm actually typing up a document I really said I was going to type up a week or so ago. And for those of you who are listening to this video who knows about that document I was typing up, y'all know I'll reach out to you. But there's a petition I'm working on that I'm gonna use. But I'm also gonna create a template version as well. Once I perfect this, y'all, it's gonna be on and popping. It's gonna be on and popping. Now, at the same time, I'm not gonna be going public, like loud about it. I don't believe in spewing out every damn thing I know. That's how people end up dead, getting in trouble, bringing unnecessary attention to themselves when they talk too damn much. So it won't be me. So I don't have a problem studying this stuff and sharing a little of that, sharing what I know publicly. But there's some things that I do know I don't care to talk about on a video. I've said that in many videos prior to this one. But anyway, let me stick to the topic. What I'm talking about today specifically is presumptions. Some people still don't understand what a presumption is. Okay, I might need to put that in my Google search real quick so y'all can see. I don't know, I like to type in legal definition. That's how I do things. Presumption. Cornell law. You know we're good for using Cornell law. A legal inference that must be made in light of certain facts. Okay. Most presumptions are rebuttable, meaning that they are rejected if proven to be false, or at least thrown into evidence doubt by the evidence. Okay, thrown into evidence doubt by evidence. Other presumptions are conclusive, meaning they must be accepted to be true without an opportunity for rebuttal. Okay, so many things that let me see if I can find it. It was a document we used to talk about 12 presumptions of law. I'm gonna see if I can find that real quick. I did that years ago, but I think I might can use that in this particular video. I did a video on 301 and 302. Y'all can rule 301 and 302. Y'all can go back and look at that yourself. That goes into presumptions as well, because I'm really trying to drive home the point about this, about the 12 presumptions, about presumptions of court. Okay, this was it. Do I really want to go through this? I guess I'll do it. A Roman court does not operate according to any true rule of law, but by presumptions of law. Therefore, see, this is the reason why I pause about doing this, only because this is not this is something somebody typed up. This is not like a government website. It could be real. I'm sure there's some truth to what they're saying, but it's not a government website. It's not a law dictionary. It's it's something that somebody uploaded to this website right here, Squarespace. Okay, so, and not saying it's not good information, but that's one of the reasons why I was kind of hesitant about it. Like stuff like this here, presumptions in civil proceedings. This would be more like what I was studying, because it basically teaching you how to do the game, how to play the game. It's telling you what they're doing. The government is telling you what they're doing. Okay, so this is what I'll go here, and I'll just let my conscience be my guide on it. Y'all roll with me. Okay, this is 3.01 presumptions in civil proceedings. Say this rule applies to civil proceedings, and it might say the same thing that the other article said, but I feel comfortable doing this. I've done 12 presumptions of law. I've done that before years ago, and I'm really trying to stay moving forward, not like standing on old stuff, even if it's still good. I mean, I want some fresh material right now. So let me flow with this here. Y'all roll with me. This rule applies in civil proceedings to a presumption, which as provided in subdivisions 2 and 3 is rebuttable. It does not it does not apply to a conclusive presumption, that is a presumption not subject to rebuttal. or to an inference which permits but does not require the tier of fact to draw a conclusion from the proven fact. Okay, number 2. This is, keep in mind, we're talking about presumptions in civil proceedings. Y'all dealing with, especially family court, child support, stuff like that. These are civil proceedings. Anything dealing with contracts. Okay, a presumption is created by statute or decisional law. Okay, and requires that if one fact, the basic fact, is established, the tier of fact must find that another fact, the presumed fact, is thereby established unless rebutted as provided in subdivision 3. Okay, guess this would be subdivision 3. Unless a court determines that a presumption is not applicable, the party against whom the presumption is invoked may rebut the presumption by disproof of the basic fact or presumed fact. Okay, that lets you know when somebody dragging you into court, they already got presumptions already. They're moving based on presumptions. Okay, the party for against whom the presumption is invoked. Against, that means you're the one, the straw man is the defendant. Okay, I'm just using straw man for the sake of conversation so y'all can understand what I mean when I'm talking about the all caps name. I'm talking about the straw man. Y'all know that. I try to get away from using straw man, but it's in the damn law. It's in the Black's Law Dictionary. So people try to act like don't use the word straw man. What's a straw man? And trying to bash people for using the term, but it's in the damn Black's Law Dictionary. So anyway, let's see. The party against whom a presumption is invoked may rebut the presumption by disproof of the basic fact or presumed fact. So you just got to disprove it by disproof. Basically, you're putting some evidence on the record to rebut their presumed fact or their basic fact. Upon presentation of the rebuttal, upon presentation of rebuttal evidence, the court shall, as provided by the statute or decisional law, establish the presumption either itself determined that the presumption has been rebutted, in which event the court shall not submit the presumption to the finder of fact. Shall not submit the presumption to the finder of fact. Okay. Instruct. I was thinking for a minute. Let's see. Instruct the tier of fact to find that the presumed fact exists unless the tier of fact is persuaded that the presumed fact does not exist. So basically, there's different ways you can rebut them. This is rebuttal evidence. Examples of rebuttal evidence. Upon presentation of rebuttal evidence, the court shall, as provided by the statute or decisional law, establishing the presumed fact, either. See, this is what the court do. Once you present the rebuttal evidence, this is what the court does. Okay. They'll proceed as set forth in paragraph 2, right here, when the statute or decision law establishing the presumption does not otherwise dictate. C, unless, okay, that's the end of number 3, and then here was number C right here. Then the court shall, let's see, unless applicable statute or decisional law provides otherwise, the burden of persuasion necessary to rebut a presumption is substantial evidence. Okay, so you need evidence to rebut the presumption. And there's different ways to presume, depending on what it is that's being presumed. Okay, first and foremost, like I'm doing a study on subrogation as well. Y'all might want to look off into that subrogation. I'm revisiting that topic, behind the scenes, because I'm understanding that they got you coming in with the presumption that you are the debtor. And the debtor is the straw man. Okay? You're not the straw man. You're actually the one who actually you're the private American, the living man. You are the living for one. Okay, you are the living man or living woman who's controlling the straw man. So that chain, so you're actually expressing a different trust than the trust that they're implying. They're implying that they are the creditor. The state is the creditor, and you are the debtor, because they're creating a body attachment, pretending as if, going with the presumption that you are, for one, dead, because that's what all caps name is. That's why they have letters of administration, because that's where a judge get their power to administer your estate in the first place, is based on your presumption of death. And that's how they get the letters of administration. Go back and look at my video on letters of administration. It speaks about that. I show it in the Georgia statutes, where they once they establish the presumed death, they were an order of it's like an order that they put in, basically presuming that you're deceased, and that's what gives them. That's how probate court is actually able to establish them, grant them the power with letters of administration to administer your estate. And here you are on the record as deceased, and that's what gives them power when you're going to challenge jurisdiction. That's how they got jurisdiction. Okay, you killing jurisdiction when you put evidence on the record that you actually prove that you are alive. Just proving that you are alive. I presumed, this is just my assumption, you should be able to prove that, not just on the record, but you should be able to prove that privately, because men and women, they deal with things privately. Okay, they don't deal with things in open court. Only when you're in open court, they only see you as a legal fiction in open court. Okay, so unless you have something on the record like a special appearance document, something when you're making a special appearance and you stating who you are on that record under, with a state of, special appearance document of some sort. Matter of fact, no, I'm not gonna go there yet. I don't want to get distracted. Let's see. Do I want to read further into this here? But I want to move away from. Let me see if there's something else in there I want to go across before I close it out, because I don't want to make this video I don't want to drag it out. Right here they're talking about evidence, subsection 302 again, favored and uniform burden of persuasion, preponderance of evidence. Remember, you can go back and look at 301 and rule 301 and 302 that I showed you on that one. Did a video on that already, so I don't need me jumping on that again. I'm really kind of jumping into this probate stuff a whole lot, because I'm seeing that probate is where the jurisdiction originally starts at. And see, and that creates a presumption when, with respect to a fact, or provides that a fact is presumed, the tier of fact must find the existence of the fact unless and until evidence is introduced that supports the finding of its non-existence. Same thing I just read recently. Let me see. I'm gonna see if I see anything else I need to pull out of this article. It's probably a lot of meat and potatoes in this article. I'm really browsing right about now, because I read that first part that I just read to y'all. I read it before I started recording, and I'm like, let me go and make a video about this. So I feel like it's some pretty good information. You can actually go back and subsection 3. Did I read this part? I think I stopped at here. Subsection 1, notes. Let me play with these notes. Subsection 1 defines the scope of this rule. It begins by limiting the application of this rule to presumptions in civil proceedings. Presumptions in civil proceedings are governed by a separate guide to New York Evidence Rule 303 and 305, or 3.03 and 305, because constitutional principles as developed by the United States Supreme Court and the Court of Appeals limit the operation of a presumption to a criminal proceeding. The rule further limits its application to a rebuttable or true presumption as defined in Division 2. It expressly excludes the conclusive presumption and an inference from its scope. Let's see. A conclusive presumption, also known as a irrebuttable presumption, requires a tier of fact to draw a particular conclusion after certain specified facts are established, regardless of proof of the contrary. And that's these are case laws that is actually quoting right here. You see that for yourself. There's more than one case law. So it is not true. It is not a true evidentiary presumption, but in reality, a rule of substantive law expressed in terms of rules of evidence. As Prince Richardson verse on evidence, subsection 3-103. And that's also Derby versus Prewitt. Let's see. Irrebuttable presumptions have their place in law, but only where public policy demands that inquiry ceases. Conclusion. Let's see. Conclusive presumptions have been created under the common law and by statute. Yes. Cordu versus Guggenheim. Anyway, there is a conclusive presumption that the parties intended to integrate in the deed every agreement relating to the nature or extent of the property to be conveyed. After 2 years from the issuance of such certificate of sale or other written instrument, no evidence shall be admissible in any court to rebut such presumption, unless the holder thereof shall have procured such certificate of sale or such other written instrument by fraud, or had previous knowledge that it was fraudulently made or procured. This kind of reminds me of my ex. I have an ex that bought a house in Lawrenceville. She was actually, it was a foolish move she made because she had an ex-boyfriend living in the damn house. And they agreed before our time, they agreed that she would get this house, and something, I'm not going to, express what she did, why they did it, but bottom line is the agreement was for her to only have the house for a few months. I guess he's supposed to get his credit right or whatever, and they're supposed to refinance it and get it in his name and out of her name. Instead, his plan was to do a quick claim deed on the house. Keep in mind, the house is in her name and her name only. He did a quick claim deed on this house, and he didn't do it with her permission. He used somebody else, probably a notary that he knew personally, that did not require them to properly identify themselves. And I don't know if she went through legal remedies to get her house back, but they went with the presumption that the house is in his name. He owns the house. Now, keep in mind, it's still on her credit. The loan is still in her name, but the house was in his name. And she had to go into the county recorder's office to find this deed that this quick claim deed he done created. That deed would be, if he used that in court without anything to rebut it, it would be presumed that this house belongs to him. But then if she could prove that there was some fraud put in place in order for him to put that house in his name and out of her name, then that would rebut this presumption. The deed that he's using as evidence. If that makes sense, y'all. I'm using that as an example because that's what this sounds like. It sounds like a good example that's similar to this here, because it looks like some solid evidence, because you got a deed put right here. Oh, this deed right here, he got this house. This is his house. But then there's a fraud put in place. Like, she didn't actually sign this document. Who signed on her behalf? What happened with this? How was this thing put together? And she's able to use evidence to the contrary to prove that the original evidence that was used was fraudulent. And so that's how she was able to get her house back, because she was able to prove fraud took place. Okay, off of that topic. I don't want to say too much about, the back end of what they were really trying to. Anyway, an inference permit does not require the tier of fact to draw a conclusion from the proven fact. Okay. Let me see what we talking about. Subdivision, traditional definitions of presumption. So not the difference. Say, okay, let me just keep moving forward. Let's see. An inference permits, but does not require the tier of fact to draw a conclusion from the proven fact. Nothing. Say nothing. The difference between noting the difference between the inference, which merely allows the tier of fact to draw a conclusion from a proven fact, and a true presumption, which places the burden upon the adversary to produce evidence to rebut the presumed fact. In this connection, the Court of Appeals has noted that a study of the opinions of the appellate court of the state revealed that judges have used the terms inference and presumption indiscriminately and without recognition that the inference and a presumption are not identical in scope or effect. Okay, subdivision 2. Let me see what this is talking about right here. I'm gonna read this little part right here. Let's see. Subdivision 2 sets forth a traditional definition of a presumption. A presumption has been defined to be a rule of law that court and judges shall draw a particular inference from particular facts or from particular evidence unless and until the truth of inference is disproved. This is the type of stuff I look for right here. This is a case law. That's Platt versus Elias. Let's see. I could be mispronouncing words. Let's see. A presumption is a particular inference that must be drawn from an ascertained state of facts. Okay. As you can see, let's see. I'm pretty much kind of dancing around and hoping y'all getting this here when it comes to presumptions. And because I'm not going to read this entire thing, let y'all read this at your leisure. I actually found this document by typing in your Google search 12 presumptions of court. Scroll down to this unified court system. 3.01 presumptions of civil proceedings. So it basically lets you know that they're actually using presumptions when it comes to that. Burden of proof and presumptions. Let's see. This is .coms. Let's see. Amendment 14, section 5.4.49, burden of proof. The Constitution annotated. Okay. 14th Amendment, section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Citizens of the United States and subject wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protections of the law. State legislature have the authority to establish presumptions and rules respecting the burden of proof in litigation. That's key right here. What the hell is that? Oh, let me back up. It showed it right there. Let me see. Right here. It's a footnote. Footnote on the right side right there. Congress's power to provide rules of evidence and standards of proof in the federal courts stems from its power to create such courts. Stems from its power to create such courts. Okay. And see, in the absence of congressional guidance, the court has determined the evidentiary standard in certain statutory actions. That's when I hit this little hyperlink, number 1, to read the footnotes on the right side. That's what I was reading. However, the Supreme Court has held that the due process clause forbids the deprivation of liberty or property upon application of a standard of proof application of a standard of proof. Too lax to it to ensure reasonable, accurate fact finding. The court has opined that the function of a standard of proof that has as that concept is embodied in the due process clause and in the realm of fact finding is to instruct the fact finder concerning the degree of confidence our society thinks he should have in the correctness of factual conclusion for a particular type of adjudication. What does this say? Okay. With respect to presumptions, the court has held that presumption does not violate due process clause as long as it is not unreasonable and is not conclusive. I think this touches me right here, simply because when you flow with the presumption of death, when you go before a court and you challenge a judge, where did he get his power? You challenging the jurisdiction. Where do you get your authority? And they don't answer it. They'd rather just start adjudicating without proving on the record where they get their power, their authority from. See, this is where a writ of Corinto comes in at. Okay, because the presumptions they flow with as if you are deceased, that's where they get their power from, is those letters of administration that they got from probate court. Okay, and so they're presuming they're going with the presumption that you're actually deceased and you're acting as the estate and not acting as the one who's living, who's supposed to be controlling the estate. If you are standing before this judge, how are you presuming I'm dead and I'm standing right here before you, looking at a man right here? How can you? That's an unreasonable presumption. It's unreasonable to me. This is just me. Say it's not conclusive. It says it's not unreasonable and it's not conclusive. Let's see a statutory. Matter of fact, let me click something real quick. I'm gonna go back to that. Writ of Corinto may issue to inquire into the right of any person to act any public office of duty of which he or she is in fact discharging. It may be granted only after the application by some person either claiming the office or interested therein. It's like, let's see. As a matter of fact, let's go deeper. Let's see. By what authority? That's what Corinto means. The term Corinto. Let's see if I'm pronouncing it right. Warrento. Okay. Warrento. Okay. I just been messing. I told you I be mispronouncing words sometimes. I be moving fast. I be thinking fast, but I be mispronouncing words like a mug sometimes. I'm like Steve Harvey sometimes. Let's see. It's a Latin word, by what authority, as in, by what authority does this person hold this office? Okay. Where do you get your authority to administer my estate? Where'd you get it from? You standing right here looking at a living man. Where do you get this authority from? So this is one of the reasons why these types of writs are so powerful. Because once you call them on that, they can't rebut it. Because you're looking at them. I've known cases that get thrown out by this. By writ of Quo Warranto. Quo. It's like a warranto. Like a warrant with an O on the end of it. Quo Warranto. Anyway, I say it the way I say it. You get the point. God damn it. But anyway, by what authority do you have to administer my estate? If you file in a court case, an affidavit, with two witnesses, say something like what I'm typing up with, you got two witnesses on their basis. They're signing and they're agreeing that they have seen you and you are alive. You are in fact alive You are signing. You're petitioning it. It's a sworn document. It's it's an affidavit or petition, however you want to call it, and it's sworn. It is true and correct. And you got witnesses, 2 witnesses. Say 2 witnesses. Every word should be established by 2 witnesses. 2 or 3 witnesses. Here we go. That's why I didn't throw my Bible away, y'all. I'm full of scripture. I might cuss, but I know this stuff. This is the 3rd time I'm coming to you. Every matter must be established by the testimony, get out the way, of 2 or 3 witnesses. Okay? It shall be established, every matter must be established by the testimony of 2 or 3 witnesses. So you create a document. You create a document and you got 2 witnesses, 2 or 3 witnesses attesting that they have seen you. You are alive. You have rebutted the presumption of death. And that thing is on the record. Matter of fact, that just might be why all them judges in Muskogee County keep on recusing themselves from any court case I open up now. I got some on the record in there that rebuts the presumption of death. I filed it in there myself. Now that I think about it. And everybody, now there's no judge on my case in that county, but I got a case in that county. But they will not. But the first thing they did when I filed that case, it was what's it called? What I'm talking about, y'all? The writ of habeas corpus. File that thing. Now, before I filed that in there, way before then, I actually did. I was on this the presumption of death back when COVID started in January, and I filed something in that county. I filed something in the miscellaneous files rebutting any presumptions of death. Maybe that has something to do with why they, rebut everything. Why they not rebut everything. Why they put in an order of recusal, and every judge in the Superior Court signed that order, all of them. So none of them would touch it. Even when I tried to do a name change decree, they all recused. They put an order in that too. So I couldn't even get no judge in that county to administer any court case I had going on over there. So that's why they got maybe why they have another judge. And maybe why they have another judge, doing my case that's from another county. So that could be it. I don't know, but that's just it makes sense. It would make sense if that's why they're doing it. I don't know, because there is evidence on the record that I am alive. So anyway, and that's been 3 years ago. Maybe they may start doing it again after 4 years, because here in Georgia, 4 years, the presumption is there again. Okay, but anyway, moving forward, by what authority? They don't have authority if you got evidence on the record that you're alive. They don't have authority to administer your estate at that point. No, they just don't. Okay, now go back and look at my rebuttal of presumption of death videos from the past, and you go back and revisit that. But that's something different. Okay, now here we go. Where we at? I guess I'm starting to heat up a little bit now. I'm thinking and reading at the same time, and I'm really flowing instead of just sticking with the script. So with respect to presumption, the court must. I think that's where I stopped at. With respect to presumption, the court has held that presumption does not violate the due process as long as. I think I read this already. As long as it is not rebuttable. I was talking about something about unreasonable. Yeah, that's what it is. It's what I read. Unreasonable. Okay. A statute creating a presumption that is not entirely arbitrary and operates to deny a fair opportunity to rebut it or to present facts pertinent to a defense is void. A statute creating a presumption that is entirely arbitrary and operates to deny a fair opportunity to rebut it or to present facts pertinent to a defense is void. Okay. On the other hand, the court has sustained legislation declaring that the proof of the fact. So I guess I'm thinking right there, right here. So if I'm filing something on the record and I'm actually requiring that she present to the court evidence that's superior to mine or precedes mine, that's before that was existed way before mine, a claim that's higher than mine. I can't just present evidence and not give her a chance to, not require her to prove on the record her claim being higher. I'm thinking out loud, y'all. On the other hand, the court has has sustained legislation declaring that proof of one fact or group of facts shall constitute prima facie evidence of a main or ultimate fact of if there is a rational connection between what is proved and what is inferred. Applying the test laid out in Matthews versus Eldridge to determine what process is due in a particular situation, the court has held that a standard at least as stringent as clear and convincing evidence is required in a civil proceeding to commit an individual involuntarily to a state mental hospital for an indefinite period. Similarly, because parents interested in retaining custody of their children is fundamental, the state does not terminate parental rights by a preponderance of the evidence. The burden of proof is to award money damages to an ordinary civil action, but must prove that parents are unfit by clear and convincing evidence. The court has upheld application of a traditional preponderance of evidence standard in paternity actions. Okay. Yeah, so the thing is, like, a lot of times people think that men or fathers don't have rights. You have rights. It's just that they operate based in the best interest of the state first. They don't worry about what's fair for the kids off the rip. They don't give a damn about your kids. They don't give a damn about baby mama either. So they they there to make money first. And if they can victimize one of you, and most of the time it's the men, then that's what they're gonna do. And it's our job as men to shut the bullshit down. And of course, not just continue to. We shouldn't have to have strokes, headaches, and all types of mental illnesses and all types of old crazy shit going on in our health, in our stress, and in our lives in order to get fairness in court, because they took an oath to be impartial and fair, and we have rights to have equal protection of the law. So that unfair shit they do, we got to start calling them out on that shit. Okay. Furthermore, parental unfairness must be established affirmatively and may not be assumed based on some characteristic of the parent. See, this is what they'll use. They'll use characteristics of the parent. They use this all the time in child support cases. Y'all know that, right? I'm sure y'all that's on child support know this. They'll use a false accusation, something to make like, you unfit, that you do all types of this and you do all types of that. And it's more like criminal. Damn, there'll be like a criminal accusation that they'll have to make it look like you're unfit. So it must be established affirmatively and may not be assumed based on some characteristic of the parent. Just because you don't like me because you think I gamble too much, or I don't come around as much as you think I should come around, and I don't pick him up all the time, or whatever shortcoming that you think I may have, mean that you automatically get to just make this assumption that I'm unfit. And that's not me, y'all. I'm just using these as examples. Sometimes people will use accusations that it has nothing to do with the unfitness of the parent. That there was no neglect, there was no abuse, there was no, no child molestation or no stuff like that. Nothing going on like that. No domestic disputes. So they'll use because he's a cheater or something like that. He cheated on me during the marriage, or he cheated on me, whatever. Something that has something to do with his character. It has nothing to do with his unfitness as a parent. He or she may be a terrible boyfriend or girlfriend, husband or wife. It does not mean that they're a bad parent. They may be a bad spouse or bad girlfriend or boyfriend. Okay? So that's not the same. So you can't make an assumption based on that. Let me see what this says. Statutory presumption that a child born to a married woman living with her husband is the child of the husband defeats the right of the child's biological father to establish paternity. And the only thing, and that's another presumption they're talking about too, because she's married by law. Her straw man and his straw man they're deemed one in law. So anything that's created while they're in contractual agreement, anything created within that contract is presumed to become a part of both of them. Okay, so keep in mind, this ain't the living and the dead are two different realms. Okay, so once you establish, like, how can I say? Once you establish I guess that's probably why they got this paternity of establishing paternity, when they talking about the DNA test and all that stuff like that, because DNA deals with the living. But I better kind of stay involved with that one for a minute, because they use that to bring it in the statutory realm too. They'll use that. So they create a body attachment as if you're operating as a dead, but they don't mind using your living tissues to keep on moving forward with some bullshit. Okay, for a time, I need to drink another Alka-Seltzer. For a time, the court used what is called a irrebuttable presumption doctrine to curb legislative efforts to confer a benefit or to impose a detriment based on presumed characteristics of a person. In Stanley versus Illinois, the court found invalid construction of a state statute that presumed unmarried fathers to be unfit parents and prevent them from objecting to state wardship. You read that little part. Oh shit! Let me do that. The court likewise struck down mandatory maternity leave rules, requiring pregnant teachers to take unpaid maternity leave at a set time prior to the date of the expected birth of their babies, based on a conclusive presumption that every pregnant teacher who reaches a particular point of pregnancy becomes physically incapable of teaching. Got someone there to do that. In another case, see where they're going with presumptions? They're using different situations with presumptions. Okay? They're using different situations when it comes to presumptions. And kind of touching on different things when it comes to presumptions. And I'm almost at the end of this here, so I'm gonna go on to the end of it. In another case, the court opined, opined that a state may require that non-residents pay higher tuition charges at state colleges than residents, and assume that a durational residency requirement must be permissible as a prerequisite to qualify for the lower tuition. But it was impermissible for the state to presume conclusively that because the legal address of of a student was outside the state at the time of the application, or at some point during the preceding year, he was a non-resident as long as he remained a student. Instead, the due process clause require that the student have the opportunity to show that he or she has become a bona fide resident entitled to the lower tuition. Similarly, the court invalidated the food stamp program provision, making ineligible any household with a member age 18 or 18 or over who was claimed as a dependent for federal income tax purposes the prior tax year by the person not himself eligible for stamps, holding that the provision created a conclusive presumption that fairly often could be shown to be false if evidence could be presented. The rule that emerged from these cases was that the legislature may not presume the existence of decisive characteristics based on a given set of facts unless it can be shown that the defined characteristics do in fact encompass all persons and only those persons that the legislature intended to reach. The court limited the irrebuttable presumption doctrine in 1975 case Weinberg versus Salfi upon the Social Security provision requiring that the spouse of a covered wage earner must have been married to a wage earner for at least 9 months prior to his death in order to receive benefits as a spouse. Purporting to approve but distinguish prior cases, the court imported traditional equal protection analysis into consideration of due process challenges to statutory classifications. The court opined that extension of the prior cases to government entitlement classifications, such as Social Security Act qualification standard before it, would turn the doctrine of those cases into virtual engines of destruction for countless legislative judgments, which have hereto been thought wholly consistent with the Fifth and 14th Amendment to the Constitution. There is some uncertainty about the viability and scope of the irrebuttable presumption doctrine since Salvi, and the doctrine has rarely appeared on the court's docket in recent years. In Turner versus Department of Employment Security, decided after Salvi, the court invalidated the statute, making pregnant women ineligible for unemployment compensation for a period extending from 12 weeks before the expected birth until 6 weeks after childbirth. By contrast, the usury versus Turner Eckhorn Mining Company, the court held that a provision granting benefits to minors irrebuttably presumed to be disabled is merely a way of giving benefits to all those with a condition triggering the presumption. People will take advantage of stuff like that. Okay, but I'm gonna stop right there, y'all. I think I've gone far enough as far as when it comes to presumptions. You have to actually rebut those presumptions when it comes to anything pretty much. You are the living, for one. You got to understand that you are the living man, the living woman. You have to first and foremost understand that you are not the borrower, you are the lender. Shalyn. Okay. Keep in mind, you never borrowed anything from anyone. You just don't know that. The straw man is the debtor. You are never the borrower. For the Lord thy God blesses thee as he promised thee, and thou shalt lend unto many nations, but thou shalt not borrow. And thou shalt reign over many nations, but they shall not reign over thee. If as long as you stay in the land of the living, know who you are as a living man and a living woman. First and foremost, the first presumption you need to be rebutting is the fact that you're dead. You are not dead. The presumption that you're dead, not the fact that you're dead, but the presumption that you're dead. You're not dead, you are alive, and the first thing you need to be trying to do is you need to put on the record is rebut that presumption first and foremost. That's what gives these judges the ability to even administer your estate. I'm gonna close out with not this Bible verse, but I'm gonna watch this here. I found this in Texas. This was crazy. Watch this here. Rebuttal. Presumption of death. Texas. I was on the phone with somebody from Texas, so that's how I found this. And I thought because I'll be looking up people's stuff in their state. This is Texas now. Right here. Let's see. Where is it? Let's see. Presumption of death. Not presumption of death. Rebuttal of presumption. Oh, this is it. A person absent himself 7 years shall be presumed dead unless it is proved that the person was alive within the 7-year period. Okay, that's not what I was looking for. But I'm gonna find it real quick. Let me back up. Rebuttal of presumption of death. As a matter of fact, I said letters of administration. Here we go. Letters of administration, Texas. That's what I looked up. Watch this. Here we go. Estates Code, Title II, Estates of Decedents, Durable Power of Attorney, Initial Appointments of personal representative, and Opening of Administration. That's what judges are, they're administrators. Application for letters of testamentary and of administration. What does it say? The first thing it says right here, letters, it says administration before death void. Administration of an estate of a living person is void. I rest my goddamn case. Emeralds, signing out.